welcome to meeting number 17 of the House of Commons Standing Committee on Justice and Human Rights. And welcome to our two new members, Madame Elizabeth Briere and Mr. Randeep Sarai. Welcome. We're very excited to have you here on this committee. Bonjour.
Good morning and welcome.
Today's meeting is hybrid, but I understand that there are no members in the room, which is excellent. We will be enforcing strict measures if you do choose to show into the committee rooms at later times, but I'm glad that nobody is there today. We're all virtual, except for Mr. Clerk. I'll be keeping an eye on your physical distancing measures there, also lonesome in your room. So in order to ensure an orderly meeting, I'll outline a few rules, which I'm sure most of you know already. Just understand that interpretation is available to you via the interpretation selection at the bottom of your screens. You will see that there is the mute button and the stop video. Members should be having their cameras on at all times. Only have your microphone open when you are speaking. Before speaking, please do wait until I recognize you by name to maintain order. And when you're not speaking, please make sure that your microphone is on mute. And a reminder to all members that and witnesses that all comments should be addressed through the chair. With regards to the speaking list, we'll try to do our best, Mr. Clerk and I, to ensure that we maintain an orderly speaking list. You will notice the raise hand function, which I see that Monsieur Fortin has used already. On the bottom of your screen, that will create a speaking list for me to follow. So please do use that button. And so before we start into it, we do need to adopt our minutes for the meeting on the agenda that we had last week. We'll go into that. Monsieur Fortin, is this a point of order or?
No, c'est pas un point d'ordre.
No, it's not a point of order, Madam Chair. Before hearing the witnesses, I would like to talk about my motion. I did send a notice about this a while ago. I don't know if I can present my motion right now.
A full agenda at this time, but if it's okay with you, can we adopt the meeting minutes of the subcommittee agenda? If I can just ask all members if everybody agrees, if there are any comments, the meeting minutes were circulated to all members. If I can see a show of thumbs for approval of the subcommittee agenda, and I see thumbs up from everyone. Thank you very much. That is adopted. All right, Mr. Fortin, would you be okay if we go through the witnesses? I don't want to keep them waiting with this study.
Je ne crois pas que ça va être très...
It should not be very long. I think you've all received this motion and that the committee report to the House that we should create a special committee to examine the nomination of judges. I could read the whole motion, but that would take a bit of your time. I think everyone has already read my motion. So, Madam Chair, I would like this to be adopted this morning, and I think the ideal way of doing this would be to deal with this right now and then listen to the witnesses afterwards. Thank you, Mr. Fortin.
Yes, Madam Chair, we had extensive discussions about sort of next steps at the steering committee meeting, and this is an important study. It's a subject of a study that also dovetails with a private member's bill that's been tabled by Mr. Garrison. We have the witnesses before us, and I believe we should hear from those witnesses and commence the study and not keep them in waiting in attendance. So I would move to adjourn debate.
So that is a dilatory motion. Mr. Virani, I'll call the vote immediately. So go ahead, Mr. Clerk.
Madame la Présidente.
Madam Chair, could I please answer I would like to reply to what Mr. Virani said. I didn't yet have the chance to debate my motion.
But Mr. Virani has moved to adjourn debate on that motion, and it is a dilatory one, so that means that there is no debate that pursues after that motion has been moved, and I, as chair, must call the vote right away. So if the vote is defeated, then obviously we'll continue to debate into your motion, but at this time, Mr. Clerk is about to administer the vote. So go ahead, Mr. Clerk.
Madame Brière?
Madame Brière?
Yes.
Mr.
I vote yes.
Mr. Cooper?
I vote against.
Ms. Findlay?
I vote against.
Monsieur Fortin?
Je suis contre.
Mr. Garrison?
In favor.
Mr. Kellaway?
Yes.
Mr. Lewis?
I vote against.
Mr. Maloney?
I vote yes.
Mr. Moore?
Against.
Mr. Sarai?
I vote yes.
And Mr. Virani?
I vote yes.
So, yeas pour 6 et nays contre 5.
Thank you, Mr. Clerk. So the motion does carry, and debate on Monsieur Fortin's motion is adjourned until at a later time. It is now my pleasure to invite our witnesses from the Department of Justice and the Department of Women and Gender Equality. From the Department of Justice, we have Natalie Levman, who is Senior Counsel, Criminal Law Policy Section in the Policy Sector. We have Stephanie Bouchard, Senior Legal Counsel and Director, and we have Claire Farid, Director and General Counsel from the Department of Women and Gender Equality. We have Lisa Smiley, Director General, Communications and Public Affairs Branch, Research Results and Delivery Branch. Welcome to the witnesses. Now we will have 2 opening statements of 5 minutes each, and then we'll go into our round of questions. So over to you. I believe it's Ms. Levman. You're starting off.
Madam Chair, if I may, I don't think that Ms. Levman has arrived yet in our virtual session, so that will be up to...
So from the Department of Justice then,
Thank you.
Whomever is presenting. Thank you.
Stephanie, will you go ahead, or would you like me to go ahead first?
You might as well go ahead, Claire, and maybe I'll give a chance for Natalie to join. I know she's with the committee clerk trying to get her in the meeting. If not, I'll give her remarks on her behalf.
Okay, is that okay with you, Madam Chair?
Absolutely. Please go ahead.
Okay,
Ms.
thank you. Okay, thank you. So good morning. I'm the director of the Family and Children's Law team at Justice Canada. Thank you for the opportunity to say a few words about the inclusion of the concept of coercive and controlling behavior within federal family law. Changes to the Divorce Act that will come into effect on March 1, 2021 include a broad evidence-based definition of family violence that specifically identifies coercive and controlling behavior. For the purposes of the Divorce Act, family violence will be defined as conduct that is violent or threatening, that constitutes a pattern of coercive and controlling behavior, or that causes a family member to fear for their own safety or for the safety of another person.
Ms. Farid,
yes.
Apologies. Can you just keep your microphone closer to your mouth for
Yes.
interpretation? Thank you.
My apologies. Would you like me to start again or just continue?
Yes, please. Go ahead. Let's start again, please.
Oh, start again. Okay. All right. Okay. So I am the director of the Family and Children's Law team at Justice Canada. thank you for the opportunity to say a few words about the inclusion of the concept of coercive and controlling behavior within federal family law. Changes to the Divorce Act that will come into effect on March 1, 2021, include a broad, evidence-based definition of family violence that specifically identifies coercive and controlling behavior. For the purposes of the Divorce Act, family violence will be defined as conduct that is violent or threatening, that constitutes a pattern of coercive and controlling behavior, or that causes a family member to fear for their own safety or for the safety of another person. Behavior does not have to be a criminal offense to be considered family violence under the Divorce Act. In contrast to the criminal law's focus on determining guilt or innocence, the purpose of the definition of family violence in the Divorce Act is to assist in the determination of the best interests of the child with respect to parenting arrangements. So that is parenting time and decision-making responsibilities. The amended Act sets out a list of factors that judges must take into account when considering the impact of family violence on parenting arrangements. It specifically requires judges to consider whether there is a pattern of coercive and controlling behavior in relation to a family member. Courts must take into account all factors that are relevant to the best interests of the child and must give primary consideration to the child's physical, emotional, and psychological safety, security, and well-being. Coercive controlling violence is more likely than other forms of intimate partner violence to continue and to escalate after separation. Risk often increases after separation because the abuser feels a loss of control. Perpetrators of coercive controlling violence may be unable to differentiate their role as a spouse from their role as a parent. They may use the children as a way to maintain control over their former spouse. As a result, based on an overall analysis of the best interests of the child, courts may order remedies such as supervised parenting time to protect family members. Thank you, and I would be happy to take any questions.
Thank you very much, Ms. Farid. We'll go to Ms. Bouchard for 5 minutes. Go ahead.
Bonjour. I'm going to give the remarks that my colleague was supposed to provide, Natalie Levman. They're still trying to connect her through the committee. I apologize for the inconvenience. I am the director of the Policy Center for Victim Issues within the Policy Center within the criminal law section at Justice. Thank you for welcoming us to your study of controlling or coercive conduct within intimate relationship. Coercive control in the context of intimate partner violence refers to a pattern of controlling behavior that takes place over time and serves to entrap victims, eliminating their sense of freedom in the relationship. A broad range of controlling conduct may be employed, but the focus is on how a pattern of such conduct serves to subjugate not the individual incidents wherein abusers exercise control. Specifically, coercive control is concerned with the cumulative impact of the abuser's conduct on the victim. Legal systems have been struggling with responding to intimate partner violence and other forms of family violence for decades. Criminal law has traditionally responded to incidents of violence and other forms of abuse, not patterns of behavior. A broad range of offenses apply in the intimate partner violence context, depending upon the conduct at issue, including assault, sexual assault, othering threats, intimidation, forcible confinement, abroad, making harassment phone calls, trespassing at night, and mischief. The criminal code also requires sentencing courts to treat abuse of a spouse or a child in the commission of an offense as an aggravating factor for sentencing purposes. Additionally, as of 2015, non-consensual distribution of intimate images is also a criminal offense. Abusive spouses may also engage in this type of conduct to exercise control. Criminal Code amendments enacted through former Bill C-75 in 2019 strengthened the criminal law's response to intimate partner violence by imposing a reverse onus on bail for repeat offenders, clarifying that abusing both a current and a former spouse, common law partners, and dating partners in the commission of an offense is an aggravating factor for sentencing purposes, and allowing a higher maximum penalty in cases involving repeat intimate partner violence offenses. In recognition of the fact that abusive conduct may involve a series of behaviors that cumulatively have an impact on victims' sense of physical or psychological safety, Parliament enacted the criminal harassment offense in 1993. This offense is designed to respond to the impact of a series of interrelated incidents on victims, in particular in the context of family violence, though the offense applies more broadly. It criminalizes engaging in specified conduct that causes a person reasonably, in all the circumstances, to fear for their physical or psychological safety, or that of a person known to them. Focus of this offense is on the cumulative impact the conduct has on the victim, not individual incidents of abuse. Criminal harassment may be charged alongside incident-based offenses depending on the facts of the case. Criminal peace bonds are also available to protect victims, including victims of intimate partner violence. Peace bonds may be imposed prior to the commission of an offense where any person fears on reasonable grounds that another person will cause personal injury, including to their spouse or child, or will damage their property. A wide range of conditions may be imposed, including no contact orders, the breach of which is a criminal offense with a maximum penalty of 4 years imprisonment. 10 provinces and all 3 territories have in place family violence legislation that complements these criminal law measures. For example, this legislation authorizes emergency intervention orders, which may grant the victim the right to remain in the home and use the family vehicle. Conditions may also be imposed to restrain the abuser from communicating with or contacting the victim or members of the victim's family. In terms of victim support, the Federal Victim Strategy seeks to give a more effective voice in the criminal justice system to victims and survivors of crime in Canada. And a key component of the strategy is the program development and delivery through the Justice Canada Victims Fund. Through this fund, a range of supports are available to victims of intimate partner violence. In particular, since 2016, the Government of Canada has made funding available through the Victims Fund to the provinces and territories in support of pilot projects to provide independent legal advice to victims of sexual violence.
I'm so sorry I'm sorry, but we're completely out of the 5-minute time, a little bit over
problem.
now. But we're hoping that the rest of your testimony comes out through questions. We'll go now into our first round of questions. For members' benefit, you remember my little notes that we have, which is a 1-minute warning and a 30-second warning for keeping time so that you can ask your questions accordingly. The first round of questions will be 6 minutes each, starting with Madame Finlay. Madame Finlay, please go ahead.
Thank you, Madam Chair, and thank you to all the witnesses for being here with us today on this very important topic. I, as part of my law practice, practiced family law for many years, so I'm well aware of these issues. And I have to say, physical and verbal violence in intimate partnerships, we should all know that it negatively affects all genders and all children, whether they are the victims or witnesses. We know, I'm glad to see that the best interest of the child test remains, but we know through medical procedures, say brain scans, things we never had availability for when I was first practicing law. We know that being either victimized by or witnessing violence can be detrimental throughout one's life. And this is something that the courts did not really recognize when I first started practicing in this area. They thought once the separation happened between couples, it just all went away, which is not the case at all. One of my concerns with COVID-19 and the lockdowns, what I'm hearing within my own riding, is that people, and I'm thinking specifically of a couple of women at the moment, who are caught in these relationships are not really aware of what is available to them. In other words, they're not sure what is locked down. Are safe houses locked down? Are women's centers locked down? Can they go? Are they safe? And I'm not sure that between our federal and provincial governments, there's been enough done to let them know that there are options. So I'm wondering if the witnesses can comment on how COVID may be being used by abusers to exploit the inability of women often to call for help or to escape their situation due to lockdowns, and whether they can comment on what is they feel the awareness generally among those who are victims as to what supports are available.
Thank you, Madame Findlay. I believe Ms. Smiley, you'd like to answer that?
Thank you, Madam Chair, and I thank the member for the question. Just a quick check. Can you hear me okay? Okay.
Yes.
So thank you for raising a really important issue. It's something that's been talked about quite extensively in terms of the impact of COVID-19 on gender-based violence more broadly. So in particular, as you've pointed out, intimate partner violence. The research that we do have and data that we do have from the COVID pandemic shows that much like crises more broadly, the pandemic is increasing rates of intimate partner violence and gender-based violence more broadly. A study by Statistics Canada early in the pandemic found that 1 in 10 women were either very or extremely concerned about violence in the home during the pandemic. Since the beginning of the pandemic, according to Statistics Canada's data from police services, there's been about a 10% increase in calls related to domestic disturbances. And we know that's only the tip of the iceberg because about 64% of domestic violence does not get reported to police. Community organizations across the country are reporting increases in domestic violence and intimate partner violence. So for example, a study by Women's Shelters Canada in November 2020 found that 52% of their shelters across the country were seeing more severe, more frequent forms of violence than before the pandemic. Another example, the Assaulted Women's Helpline in Ontario has seen substantial increases in calls at the beginning of the pandemic. We're talking about the magnitude of 72% increase as of May 2020 compared to May 2019. And Canada's not alone in those trends. These have been reported globally in terms of increases in intimate partner. And we imagine why. Women are isolated with their abusers, who, for example, are engaging in controlling behavior, withholding technology, phones, controlling who they can speak to, cut off from friends and family and community organizations.
Ms. Smiley,
perhaps I'll leave it there.
Yeah, it's very important what you're saying, and we know that one of the hallmarks of abuse is isolation of the victim. We don't have a lot of time here, though, so I have another quick question. Bill C-75, which was an act to amend the Youth Criminal Justice Act, came in July 2019. It created a reverse onus at bail for persons accused of violent offenses involving intimate partner violence. I'm just wondering if there's any evidence that leading up to and during the pandemic, this reverse onus burden shift has decreased the number of reoffenders of intimate partner violence. Has that helped?
Very briefly.
I will have to defer to my justice colleagues on this outside of the scope of my expertise or knowledge.
Go ahead, Ms. Bouchard.
Thank you. This would be a question for my colleague Natalie Levman, who's, I believe they're still trying to connect to the committee. So all questions relating to criminal code amendments sort of have to wait for her expertise.
So Madam Chair, perhaps because it's a technical issue, we could get a written response if we don't manage to get the witness through.
Absolutely. I was thinking the same thing, Madame Findlay. So if we can, to the department officials, provide a written response to that question, I think members would like to know. Thank you very much. We'll now go on to Ms. Briere. Welcome to our committee. You have 6 minutes. Go ahead.
Thank you, Mrs. Chair. Bonjour à tous et merci à nos témoins.
Hello to all of you, and thank you to our witnesses. I sat on the board of Sherbrooke's Maison L'Escale, which is a women's shelter. It does extraordinary work for women who are victims of domestic violence. And in fact, there was something that's coming out with social media and instant communication technologies. It's becoming harder and harder for victims to find a safe space far away from the control of an intimate partner. Even if the partner is not necessarily physically with a partner, he can always get in touch with her. So in the bill, I'm just wondering whether we can refer to cyber violence, whether it's direct, the abuser uses technology to survey his victim in an intimate area, or cyber violence in terms of disseminating intimate images.
I will let them choose who's the best to answer.
Should I call on somebody? Ms. Bouchard?
Merci pour la question.
Thank you for the question. Unfortunately, again, Natalie is the expert on those issues, so criminal code issues. So perhaps all I can say is that indeed the pandemic has brought forth a lot of issues with regard to victims of this type of violence. People are living in lockdown. People are working from home. And throughout the country, directors of transition homes or shelters have received more calls of distress, and they're trying to address some of the problems. But the pandemic really has created a new dimension. So they're trying to create different ways of communicating with victims, sending texts at night, for instance, or in the middle of the night. So when everybody's asleep, the victim might reach out for help. So that's a bit of an improvement, but clearly at this very moment, people who work in this field are trying to find solutions, practical solutions to help these victims.
to try to reach them more effectively again in this pandemic context?
Written answer to that question, please.
Absolutely, go ahead.
Thank you. Vous l'avez souligné.
A little earlier, Madame Farid, you said that apart from exacerbating inequalities between men and women, lockdowns and the exceptional measures put in place to counter COVID have made this type of violence worse. It's also harder for victims to leave their partners, and there's an increased risk of violence because of some factors such as increased drug or alcohol abuse. Finances are suffering, people's mental health is going down, and social supports are weakening. So do you believe that this bill sends out a message that there is even less tolerance for this type of violence?
Oui, merci. Je ne peux pas commenter.
Thank you. I can't comment on that aspect of the bill, but I can say that the pandemic, as you said, has worsened problems for domestic abuse victims. Family law services are available in different forms throughout the pandemic. Today, for instance, services are available virtually to provide support. As I already said, amendments to the Divorce Act will be implemented on March 1st, and that should help.
20 seconds remaining. We're good.
Okay. Well, it's okay. I'm good.
All right, thank you. Maintenant, Monsieur.
Mr. Fortin, for 6 minutes. Thank you, Madam Chair. First, I'd like to thank our witnesses. This is an important issue, namely domestic violence and everything around that type of violence. It's always concerning that this happens in society, so I'm happy you're here with us this morning. The main question is this. When I look at the overall situation, is how we are going to distinguish between domestic type of violence and harassment and coercive or controlling behavior. These are different types of violence, and I'd like to hear what you think of the distinction between them. You're all lawyers. Ms. Farid, maybe you can answer the question, but it doesn't matter who answers the question. So I would like to know how a court will distinguish between these three different types of situations. Madame Farid, maybe you want to start? Can the witness please hold her mic close to her mouth? Thank you very much. I just wanted to say that I'm here
Ms. Farid is talking, her voice is coming out way louder than the interpreter, and it's very hard for me to hear, whereas when Monsieur Fortin was speaking, it was fine. So I don't know what the issue is there. It's very hard to hear the translation.
Thank you for pointing that out, Madame Finley. Ms. Farid, maybe we can try with you holding the microphone closer to your mouth and speaking a little bit slower and see how that gets us. Go ahead.
OK. Alors, malheureusement,
So unfortunately, I'm not here to talk about offenses. I'm here to talk about family law, so I can't really answer your question, sir. Ms. Livman.
Yeah.
Madame Livman, est-ce que vous voulez répondre?
Ms. Livman? Oh, maybe Ms. Smiley can answer.
Outside of my expertise, and so I cannot comment.
Alors, merci. Madame Bouchard, à ce moment-là?
Ms. Bouchard? I've just seen an email from my colleague Natalie Levman. She's online, but you cannot seem to hear her. Well, maybe her mic is off. She's the one who can answer that question. Thank you, Ms. Bouchard.
Can you do a little sound for us, please? I'm just stopping your time, Monsieur Fortin.
OK, merci.
Okay. So I'm understanding that Ms. Levman is just joining now, and she has not heard your question.
Okay.
So
Je vais la
Clerk,
répéter.
Mr. Clerk, if you can just confirm if she can hear us now.
I can hear you.
Perfect. Thank you very much. Monsieur Fortin, if you want to repeat your question briefly, so Ms. Levman knows how to answer. Go ahead.
Merci, Madame la Présidente. Alors, Madame...
Thank you, Madam Chair. Ms. Levman, what I was saying is that this is an important issue which we're studying. Now, this is an area of federal jurisdiction, divorce is, but so what we're discussing here is a potential amendment to the criminal code. There are already provisions for harassment and domestic violence, and now we're thinking of creating a new offense of controlling and coercive behavior. So my question to you is this: how will the courts distinguish between these types of violence? So domestic violence, harassment, and coercive or controlling behavior.
Je m'excuse.
Apologies. I figured it out now. No, I'm sorry. If I may, I'd like to answer in English. It'll be easier for me. And thank you for the question.
Correctly, you're wanting to know the difference between incident-based offenses like assault or other offenses that involve violence, criminal harassment, and then this new proposed offense of coercive control that's aimed at capturing a pattern of behavior. I just want to make sure that I have your question right, Monsieur Fortin.
Yes, exactly. Oui.
Okay. Okay. So my colleague, Stephanie Bouchard, already gave our comments and tried to make some of those distinctions. You know, of course, that traditional criminal law focuses in on incidents. So it's an incident-based approach. That said, there have been some exceptions to that rule in terms of more modern offenses, and the criminal harassment offense is, in fact, a very good example of that, because it aims at addressing the impact, the overall impact or cumulative impact of behavior that takes place over a period of time. And that's precisely what this coercive control offense that's being proposed by Bill C-247 and also is in place in the United Kingdom, Scotland, and Ireland attempts to do. It is broader than our criminal harassment offense, but it takes a very similar approach to it in the sense that the legal test would be to look at the overall impact on the victim or the recipient of that type of conduct, and to criminalize that, to recognize that spousal abuse or intimate partner violence takes place over a period of time and often involves more subtle types of behavior that serves to subjugate, or as Evan Stark says, who is one of the leading sociologists on this issue, has done a lot of research on it. He talks about it being a kind of liberty crime, resulting in subjugation of the victim.
Thank you, Monsieur Fortin. That concludes your time. And before
You're serious?
You'll have more rounds, I promise you.
Okay.
So
J'ai l'impression d'être le technicien.
I feel like I'm the technician right now.
Time when we were dealing with our challenges. Ms. Lefman, whilst we're going to the next person, can I please ask you to unplug and replug your headphone set in? Your sound is not coming from your actual microphone, so just try to twiddle with that. Mr. Garrison, you are up next for 6 minutes. Go ahead, sir.
Thank you very much, Madam Chair. And as this is the first day of our study on coercive and controlling behavior, I just want to take a second to put on the record how we got here. If we were doing a normal study of a private member's bill as the sponsor of C247, I would get to make an introductory remark. So let me just say a couple of things briefly. At the beginning of the pandemic, I did a phone around to the 2 independent police forces and 2 RCMP detachments in my riding. And in those calls, all 4 of those police commanders mentioned, when I asked, what is the main thing you're seeing in the pandemic, they each first remarked on the increase in domestic violence calls. It was interesting that it was across the riding. It was interesting that it was the immediate response of all 4. And when I had a discussion with them about how the police felt about that, they very quickly raised their frustration that their ability to act was limited only to the most serious physical violence, and their frustration at their inability to address the issues of coercive controlling behavior, which quite often, almost always in fact, are associated with more direct forms of physical violence. I did a call around then to the service providers for women's groups, women's shelter organizations in my riding, and of course found the very same thing, that they reported a very sharp increase in demand for their services. And interestingly, reported the same frustration in that in the attempt to try and keep their clients safe, they were frustrated by the inability of the police to act until it was much later on in the relationship. And so as a result of those conversations, I began to look if there wasn't more we could do as a society to address this problem. And the British example was brought to my attention by Mitzi Dean, a local MLA who's now the Minister for Child and Family Services in British Columbia. And so I drafted a private member's bill, C247, which is modeled on the British law, so that we could look at whether this addition to the criminal code could help provide another tool for addressing the problems of domestic violence in this country. Second part was to try to get more people to discuss and be aware of what's being called by some the shadow pandemic. And so I then decided to put forward a motion to this committee to conduct this study. So for me, the study has 2 parts. One, and that is to raise the profile of this very significant increase in domestic violence and intimate partner violence during the pandemic. And the second is look for solutions, which may involve my private member's bill, but there may be other solutions that we could adopt that would help address this problem. So that's how we got here this morning from my point of view. And I'm really pleased to have the department officials here to help us try and address this problem. And I'm certainly looking forward to the wide variety of witnesses we will have coming forward in later sessions. So my first question would actually be, I think, addressed to Ms. Smiley. And we've had an attempt by the federal government to come forward with a strategy to reduce and address gender-based violence. And I just want to ask Ms. Smiley whether that strategy has taken into account the phenomena of coercive and controlling behavior.
Thanks, Madam Chair, for the opportunity to respond to this question. So as the member notes, the Government of Canada does have a federal strategy to address and prevent gender-based violence. To date, there's been over $200 million in investments and an ongoing commitment of $40 million per year. And in that strategy, we consider various forms of gender-based violence, including forms related to coercive and controlling behavior. And so some of the key things that we're doing under this strategy relevant to this study that I'd like to note. On the one hand, we've made investments of over $24 million in new data and research to date. And part of that is so that we can better understand the phenomena and all of the various forms of intimate partner violence. It is so complex and for various reasons, it's very difficult to measure. And so that's one thing we're doing so that we can better understand. We're also making investments in programs. So to date, almost $17 million in 54 projects across the country that is helping service providers, organizations better support survivors and their families. That includes survivors of the types of behaviors we're focused here to coercive and controlling behaviors. Also of note, under this strategy, the Department of National Defense has invested $1.5 million to date in family support services and military member services, as well as sexual assault centers in close proximity to Canadian Armed Forces bases. Those are just some of the things under the strategy that we are doing. I think one more important thing, since it was mentioned, through the RCMP, they've invested $4.6 million in policing operations and support and are undergoing cultural competency training to make sure that officers are able to support victims and survivors appropriately. So I'll stop there. Those are some of the things that we're doing under the strategy in relation to the study.
Thank you, Monsieur Fortin. Sorry, Mr. Garrison. That concludes your time. We'll now go into our second round of questions for 5 minutes each, starting with Mr. Cooper. Go ahead, Mr. Cooper.
Great. Thank you very much, Madam Chair, and I want to thank the officials for being here as we commence this most timely study. And I will direct my first question to Ms. Levman, picking up from where Ms. Findlay left off before Ms. Levman had an opportunity to come online. Ms. Findlay asked a question about Bill C-75 and in particular the reverse onus provisions for bail in the case of persons who are charged with intimate partner violence who have been previously convicted of similar such offenses. Would you be able to speak on any impact those reverse onus measures have had?
Thank you for that question. Unfortunately, they came into force so recently that we don't have any kind of statistical or other evidence yet, but we are watching its implementation, of course, which is part of our job.
And I presume your answer will be the same to my next question, but I will ask it nonetheless, and that is another aspect of Bill C-75 is that it does provide for an increase in maximum penalties for intimate partner violence. Are you able to speak to any statistics or data there, or is it the same as your previous answer?
Yeah, not yet. We're really just about around a year out, so it's not sufficient time to be able to do any kind of assessment or evaluation, unfortunately.
Great, thank you. I want to just ask whichever official can answer the general question about access to courts in COVID. Courts have not been sitting in their regular capacity. Indeed, they were sitting often in a very limited capacity at the start of COVID for several months, dealing with EPOs and so on. But can any of the officials speak to, for women and others who are suffering domestic violence, the impact that COVID has had on their ability to get remedies through the courts?
Do you have a preference, Mr. Cooper, as to who answers? Oh, Ms.
Whoever may, yeah.
I can just provide a few comments noting that you know, there is a jurisdictional issue that we're not, you know, we're at arm's length from courts, but we do monitor what they're doing, and we are aware that there have been impacts by COVID. In fact, that information, I understand, is publicly available on the court websites and can be found there if that's helpful to the committee.
Okay, thank you for that. I guess where would I be able to find the data that you spoke of?
I believe it's on the website. That's what a colleague of mine has communicated to me. But we can look for that if you like.
That would be helpful. And I would just ask whichever official wishes to answer, if you're able to speak to, in general terms, what you're hearing from organizations across Canada in terms of how they are functioning through this pandemic, in terms of organizations that are supporting women in domestic violence situations, women's shelters, and so on.
Ms. Smiley, go ahead.
Thank you, Madam Chair. So the Government of Canada, since March, has invested over $100 million in over 1,000 shelters, sexual assault centers, and organizations providing supports to women and children experiencing gender-based violence. And so we've been working with these organizations very closely. What we're hearing from them is they are certainly extremely appreciative of this critical support that has allowed them to keep their doors open and to provide safe, critical supports and services to those who are experiencing violence during the pandemic. In fact, our funding has helped over 700,000 women and children during the pandemic. What we're also hearing from shelters and sexual assault centers is that they are seeing more frequent and more severe forms of violence during the pandemic than they were seeing prior to the pandemic. And I think that's consistent with what we're hearing from police services across the country as well.
Thank you. Thank you, Mr. Cooper. I will now move on to Mr. Virani for 5 minutes. Go ahead, sir.
Thank you very much, Madam Chair, and thank you to all of the witnesses from the two departments for being here. Appreciate your time. I want to pick up where Ms. Smiley just left off. I think there's sort of the pre-pandemic phase, and then there's the pandemic phase. And what I'm struck by is, compared to the previous government, the lack of funding that was in place under the previous federal government, and then how things turn from 2015 to 2019. And my understanding is that the funding increased from between $20 million per year for women and gender equality seeking organizations to about $65 million per year. So that's the first important point. Second important point is that I understand that the statistics show that in 2019-2020, we invested nearly $66 million in 533 women's and equality seeking organizations, which is critical. And that, again, as Ms. Smiley reiterated, that this year alone, that number will increase to 110 million. The pandemic then enters, and we know, and it's a lot of it for a person like me is anecdotal, but I appreciate the statistics that were being provided now, which are very helpful in terms of the rising claims, the rising incidents of violence that are occurring. And funding is increased to the tune of $40 million. I guess the question that I have, an additional $40 million during the pandemic to address this pressing concern. The first question that I have is perhaps for Ms. Levman. Ms. Levman, can you tell us whether the criminal tools that we currently have are sufficient? We've heard a lot about the various different heads that are provided, harassment, mischief, trespass, etc. Is a new criminal offense required that is more along the lines of a pattern of behavior rather than a specific incident from your perspective? And if so, why? Ms. Levman?
Thank you for that question. I think I would rather speak to the scholarship that I have reviewed rather than my own personal opinions, because I think that the scholarship might help the committee in terms of evaluating, the advisability of a broad offense that would capture this type of conduct. And I would bring your attention to both sociologists that have supported the enactment of these types of laws. So Evan Stark in particular, but we also have a Canadian sociologist. There's an article that is published on the Office of the Federal Ombudsman for Victims of Crime called Understanding Coercive Control in the Context of Intimate Partner Violence in Canada, that recommends that offense, the creation of that offense, but in particular recommends consultation and study before such an offense is brought into effect for a lot of different reasons, including difficulties with operationalization, training, evidentiary issues, etc. And then there's
Ms.
another...
Levman, could I just ask you just on that point? It also strikes me that if we're dealing not with an incident, but with a pattern, could you dwell on your experience with the criminal harassment charge that you mentioned to just identify for us what hurdles you might see in terms of women coming forward with testimony to evidentiate this type of pattern, and how onerous that would be on women? And Ms. Smiley, if you want to jump in on this as well, but Ms. Levman first. And I'm just taken by the fact that we know it's not a very welcoming environment in criminal justice circles when women are testifying, usually against a man, about a single incident. They're having to testify about a full pattern. What kind of toll would that take on the women as a witness in those types of proceedings, and how could we support them better in that regard? So Ms. Levman, just on that point.
Yes, well, the scholarship actually does address that. There are other articles as well that looks at the implementation of the UK offence and talks about difficulties with gathering the evidence, including difficulties with law enforcement, even being able to recognize that this is in fact what's going on, particularly, for example, when the incident comes to the law enforcement's attention because of, let's say, one violent episode, and they have to be able to situate that in a pattern of conduct that may have taken place over months or years, and that can be a struggle. And of course, the evidence would come, as you're pointing out, from the victim herself, and I will use gendered language because the statistics support me on that. And if I could just move quickly before I turn it over to my colleague from WAGE, to the other side, which is that there are also criminologists who are recommending some caution with respect to developing these types of offences, in particular from the UK and Australia. And you may know that Australia is also considering, or New South Wales is considering, a very similar private member's bill to C247. And I would bring the committee's attention to an article called The Criminalization of Coercive Control, the Power of Law, which is in the International Journal for Crime, Justice, and Social Democracy. And I found that very informative, and you may too.
Thank you very much.
Thank you. Ms. Levman, I know that you referred to a number of documents and articles just in that question. Just in the interest of the committee's deliberations, if you could send that over to us, we'd really appreciate that.
I would be very pleased.
Thank you. And if you can just call the IT people about your headphone again. Monsieur Fortin, voulez-vous commencer pour...
Mr. Fortin, you have 5 minutes now. Thank you very much, Madam Chair. Ms. Levman, I don't want you to interpret my question as harassment. It seems that you're getting all the questions now, but your expertise is very useful here. I think the challenge that we're facing here when it comes to this issue is to distinguish between the different types of behaviors. Some are already in the criminal code, others are not. So, for instance, in a discussion between spouses, and it's not always spouses, but let's take two spouses, and there might be a robust discussion, voices are raised without it being a criminal offense. And then you take it a little farther, and one or two spouses might start harassing the other. And then there's another degree, which is violence, and then there's physical violence. So it's hard for me in this evolution of behavior where you draw the line. Where is the controlling and coercive behavior? I don't know what the distinction is. I know you get this question a lot, Ms. Levman, but where do you draw the line between what is legal, what is illegal behavior, and what is harassment, what is violence, and what is coercive? Before you answer, I have a second question, and I'll put it now because I don't have a lot of time. I'd like to know how you think we should address each of these three situations: harassment, violence, and controlling and coercive behavior. So if the third, controlling behavior, does become an infraction, what kind of penalties should be imposed for each of these behaviors? And how do you define them exactly? How do you clearly distinguish between these three offenses so a judge can clearly make a decision? If you don't have enough time to answer, if the chair agrees, I would ask you to send in a written answer, as has already been requested of you. Thank you, Ms. Levman.
I think you're absolutely right that if the coercive control offense, or if it were an offense in Canada, we would see significant overlap because even turning to and I'll provide this to the committee as well, the UK Home Office's statutory guidance framework, which gives you a list of a variety of different conducts that could be considered or that should be considered risk factors or indicative of coercive control. And you'll note in that list that some of them are certainly criminal offenses, uttering threats, violence, sexual type offending. Even in Canada, we have the offense of a non-consensual distribution of intimate images that can be used to control other people. And then there are other types of conduct that really aren't criminal offenses in and of themselves, but speak to an overall pattern of behavior. So what we see often in the context of offenses that capture patterns of behavior in terms of an individual case are a variety of different offenses or charges being laid under different offenses. And that is quite common, and I would assume that would happen here. So, for example, depriving someone of their basic needs, isolating a person from friends or family, monitoring another person's time, your partner's time. All of this is considered by the UK to be coercive and controlling behavior. If you couple that also with uttering threats with violent type offenses, then likely in a case like this, you would see a variety of different offenses being laid. And so I don't think there necessarily are clearly defined lines between offenses. Certainly we try to keep the conduct separate conceptually, but there are overlaps amongst offenses, and I would think that there would be significant overlap with a case like coercive control. If we had that as an offense and it were charged, I could see criminal harassment charges being laid, assault, sexual assault, uttering threats, depending on the facts of the case. I'm not sure if that answers your question, Monsieur Fortin. You had three in there.
Oui. Avant que mon temps se termine, j'aimerais vous demander.
Before finishing, I'd like to know how you would classify behaviors which might resemble controlling behavior, but which are still legal. For instance, two spouses are arguing. It's a serious argument. Voices are raised, but there's a back and forth. So how would you classify this type of behavior, which is an animated argument and a verbal fight. The wife says to the husband, I don't want you to go hunting with your friends. And he'll say, I don't want you to go dancing with your girlfriends. Clearly, we don't want to prohibit that kind of interaction. But it's a challenge for us to differentiate amongst all these things.
Les sujets sont trop intéressants.
I'm sorry, the topics are so interesting. Sorry about that.
Absolutely. So maybe Ms. Levman, in Monsieur Fortin's next round of questions, you can answer that one to begin. Thank you. Mr. Garrison, you have 5 minutes. Go ahead, sir.
Thank you very much, Madam Chair. And I know that after today, we will have testimony from many of the frontline organizations who I think can address some of the questions being raised by Monsieur Fortin. I would like to ask about the UK example, and of course, I think we're back to Ms. Levman again, and whether or not it has been the experience in Britain that charges have been laid, and whether the offence of coercive and controlling behaviour has been successfully prosecuted in the UK. So what has been their actual on-the-ground experience with the new criminal offence?
Thank you. That's a great question. And my understanding from the statistics is that it was a bit of a slow start, and that training was necessary for police officers, and that the incidents, detected incidents, I guess you could call them, meaning incidents that have been reported to the police per year, have been increasing each year. And some of the literature that I will send to the committee will address that for you.
So that there has been then successful prosecution, that the offence, as some have suggested, isn't too vague or it isn't too difficult to prevent the police and prosecutors using this to address these forms of violence.
Well, I can't speak to successful prosecutions because I didn't read literature about prosecutions per se, and we need to remember that this offence was only enacted in 2015, so there really is limited evidence about it. But what I can say is that charges were slow in coming under that offence at first, and I understand that they have been increasing every year, corresponding with police training to help them better understand the nature of the offending, what to look for, addressing evidentiary issues, etc.
Thank you, Ms. Lesman. On the question of whether creation of a new criminal offence on coercive and controlling behavior would be particularly difficult for the victims in terms of having to provide evidence in court, I guess my question probably goes either, sorry, I've lost track on my screen where people are, to a couple of our witnesses. Would this be something that would be peculiar to such an offence, or is it something that women already face in our court system in terms of trying to respond to assault charges, to criminal harassment charges? So is it something where we need a much broader attack, or would it be something that would be more limited to this offence? Ms. Smiley?
Ms. Smiley.
Perhaps I'll step in here briefly, just to say we do know that creating more supportive and responsive justice and legal systems is important. In fact, it's one of the pillars under our federal strategy to address gender-based violence in Canada. We also know from data that with respect to other offenses, only 5% of sexual assaults are reported to police. Only 64%, 64% of spousal violence is not reported to police. So this to me indicates that there's an issue. People aren't reporting for a reason, and we need to look at our justice and legal systems and how we can create more responsive and supportive systems for victims.
Thank you very much. I believe it was Ms. Bouchard who raised the question of peace bonds. And one of the frustrations that I heard both from police and from women's support organizations in my riding was that the kinds of behavior, coercive and controlling behavior that are talked about in my proposed bill aren't really able to be addressed in the existing peace bond provisions. Could you comment on that question?
I will defer to my colleague Natalie as I was reading her note to the committee prior to her joining the committee.
Thank you. Thank you for the referral and for the question. I mean, peace bonds really do apply anytime a person fears on reasonable ground that another person will cause personal injury, including to their spouse or child, or will damage their property. So, you know, in cases where there is a pattern of behavior that indicates certain types of risk, but insufficient evidence, let's say, to support a criminal charge, peace bonds can be a very useful tool. They can be sought by anyone, and their breach can be quite a serious criminal offense, including when that's repeated. That there may be different views on how they could be used in this particular context. I don't disagree, but I do think it is an available tool and an important one, given that in criminal law we of course have you know, evidentiary issues and a very high burden to meet. So it's a very important safety tool.
Thank you very much. That concludes your time, Mr. Garrison. We'll now go to Mr. Lewis. Go ahead, sir, for 5 minutes.
Thank you so much, Madam Chair. Thank you to all the witnesses as well. Today, you know, I was a former firefighter, 7.5 years, and I responded to a lot of domestics as well. And even today, a lot of my my close family members are either officers or frontline paramedics. And you know, back in the day, domestic abuse was a major issue, and I can only imagine now. And in speaking with my family members and friends that are still on the front lines, it is absolutely gone over the top. They've charted right out. I speak to them quite often on this. So this is very good discussion, very important discussion on so many fronts. So to the Department of Justice, there have been concerns over a lack of access to the courts during the pandemic. There is uncertainty for women fleeing abusive relationships that they will be able to get their kids. How has the Justice Department been responding to these concerns?
Anybody from the Justice Department?
Perhaps I could speak to that particular issue. So as I mentioned, certainly in the family law realm, which is where parenting issues are generally addressed, as Ms. Levman mentioned, there has been a different experience in different jurisdictions, primarily related to levels of COVID. In some jurisdictions, courts have operated without closing at all, whereas in others, there has been quite an impact. Certainly, there have been some innovations in terms of moving virtual in terms of the courts, and there are many courts now that are dealing with many issues on a virtual basis. But certainly, you know, we've heard of many parenting issues that have arisen during the pandemic, and some of those cases have been particularly challenging in family violence cases. And so we have been in discussions with our federal, provincial, territorial colleagues to share best practices across jurisdictions in terms of how they are addressing some of those issues in the context of their services and courts to enable that information sharing. And as I mentioned, the Divorce Act amendments, which for the first time recognize family violence in the Divorce Act, come into force on March 1st of this year.
Thank you so much. And you actually led into my next question. So that was a fantastic answer. We appreciate that. I understand, and I believe it to be true, there's a very huge backlog of criminal cases across most of the provinces due to COVID-19. What dialogue has the department had with your provincial counterparts to address this?
I'll answer that question, but I'm afraid I don't have a substantive answer for you because it is a procedural question, and you don't have justice officials before you today who are experts in that area. But I could follow up if you like with my colleagues on that question.
Thank you. Yeah, I would appreciate that. Thanks so very much. Madam Chair, I'm out of time left. I got 1 minute. I'll go quick. Is the department currently looking at any legislative changes as a result of the pandemic and the increase in domestic violence?
From the Department of Justice?
I'm sorry, I missed the question about what kind of changes you were asking about.
Legislative changes.
Legislative changes. Well, as part of our work, we are always reviewing case law implementation of laws that have been enacted in the past to strengthen responses, and we're talking always with our colleagues at in FBT Forum to address issues of common concern. So this would be one of those issues that we keep the lines open with them about, including the procedural ones that you mentioned before.
Thank you, Madam Chair, and thank you, Madam Levman.
Thank you very much, Mr. Lewis. I will now go to Mr. Sarai for 5 minutes. Go ahead, sir.
Thank you, Chair. I want to thank all my colleagues as well as the guests. This is my first committee meeting at Justice, so I'm honored to be here. This is a deep subject to my heart. I have several women's shelters in my riding, including NISA and as well as the Surrey Women's Shelter, both providing excellent services to sometimes the most vulnerable people in our society, women at risk. And I was very pleased to find that WAGE had announced some funding for them right in the beginning of the pandemic in April, which I think helped them. Although at the time, probably nobody could predict the increased level of cases, the staggering increased level of cases. So my question to Ms. Smiley is if she can tell us how we can do better to prevent, what the government can do better to prevent some of this violence and reduce these patterns of control.
Thank you, Madam Chair, for the opportunity to answer this question. It's a very heavy question, and given the complexity of gender-based violence, there is no single thing that will fix this issue. So one thing that the government is doing right now is we are advancing a national action plan to end gender-based violence. The pandemic, as you've all heard here today, has reinforced the fact that we need a national action plan. We need coordinated action across the country, across various sectors, and it's certainly amplified its urgency. So to that end, the Government of Canada is working very closely with provincial and territorial governments to advance this national action plan to end gender-based violence. And this year, or in 2020, starting in 2020, we had engaged over 1,500 survivors, community organizations, and other experts to answer this very question. What do we need to do? And to develop the national action plan. And I think it's important to note that we met a really important milestone on this national action plan just a couple of weeks ago, when federal, provincial, and territorial ministers responsible for the status of them on January 21st and 22nd had endorsed a federal, provincial, territorial, ministerial joint declaration for a Canada free of gender-based violence. And that joint declaration does affirm a common vision, principles, and goals for responding to gender-based violence. And that work continues and will be our roadmap for addressing this issue. Thank you.
Thank you. And that was very helpful. For my next question is for Justice. From the Justice's perspective, how have you adjusted or changed your strategy to gather information and address the rise of domestic abuse cases as a result of the pandemic, knowing that only 5% of these get reported? How have we been able to get the data so we can make informed decisions and stem this problem?
From the Justice Department?
My colleague may want to speak from a family.
Go ahead, Ms. Farid.
Okay, so I was just going to say, certainly our colleagues from the Research and Statistics Division at Justice Canada would be well placed to provide some of that information. But I would say that, one project that we're undertaking at the Department of Justice with respect to the pandemic and the civil court system is to work with Statistics Canada to get some baseline data. And we will be publishing that, or the Statistics Canada will be publishing that data in the form of a Jurastat, so that we'll be able to do some comparisons pre-pandemic and post-pandemic in terms of the justice system, which will help inform policy work in this area.
Thank you. And if I have some time, I'd like to, Ms. Smiley, real quick, anything that you're doing to address the lack of data in this field? Anything that we can do to get more data?
Very briefly, Ms. Smiley.
Very briefly, as I said, to date, we've invested over 24 million in research and data. We're developing 3 new national surveys to fill data gaps with respect to this issue. In particular, we're putting out, have put out a national survey on gender-based violence. And right now we're analyzing data specifically with respect to intimate partner violence to get us a better picture of intimate partner violence. And are gathering data on specific populations as well, on students, as well as violence in the workplace.
Thank you. Thank you very much for that. We're now moving on to our next, Mr. Moore. You have the floor for 5 minutes. Go ahead, sir.
Thank you, Madam Chair, and thank you to the witnesses for appearing today. So much has changed over the last year, of course, with COVID, and I'd like to know in your federal provincial discussions or with stakeholders, I know we're going to be hearing from some witnesses that operate women's shelters in the course of our study. I represent a rural riding, and access to services there, it can be different than in an urban center. So 2 questions to whoever feels is their best place to answer it. One is the impact of COVID on the services for stakeholders that you're dealing with. And 2, is there special rural considerations we should be considering as members of Parliament? Thank you.
Ms. Smiley, you have your hand raised.
Thank you. Yes, so with respect to women living in rural areas, according to 2018 police reported data, women in rural areas experience the highest overall rates of intimate partner violence in the country. And so I think that's significant to note for this study. And given that, important to ensure that women living in rural areas particularly have access to supports and services in their area.
Thank you. And on the other part of my question on services remaining open and available, or the degree to which services are open and available, do you have a general comment on that? I know we're going to be hearing from some specific women's shelters, for example, and some people are surprised to hear that some services are still open and available, and others are kind of like we are today, hybrid, open and available, doing things differently. Any input that you have in that regard?
Absolutely. So as I had mentioned, $100 million since the start of the pandemic has been distributed to over 1,000 shelters, sexual assault centers, and organizations providing services to women and children experiencing violence. And as part of that, what this has allowed those organizations to do is keep their doors open, to continue providing these critical services. And in particular, what it has allowed them to do is hire more staff, to tailor some of their services to the pandemic context. And what I mean by that is tailor some of their services to online in order to increase access, knowing that people cannot necessarily come in to an organization. And so these organizations remain open, and the funding has allowed them to do that and has allowed them to ensure that they have staff capacity to support, as I said, over 700,000 women and children during this pandemic.
Thank you. Madam Chair, how much time do I have left?
You have 1:10.
Okay, just a quick one for Natalie Levman. Well, it might not be quick, but is there a place where, we're talking about coercive control? That's part of the discussion that we're having today, based on a motion from my colleague. And there seems to be some uncertainty, at least on my part, and based on some of the questions from some of the other members, on is there a place we can go to get a list, an exhaustive list of what would be captured by these things that fall short of what's currently in the criminal code? So what's in the criminal code is already criminal. So we're talking about something different than that. And I've heard some different examples, but where would be the most expansive or exhaustive list we could get of what would be seen as coercive control or things in a pattern of behavior?
Yes, I do think that probably one of your best sources is the UK's guidance for their prosecutors, statutory guidance framework, and I will send you that.
Okay.
A few pages in, it has a box with a full list of all of the behaviors that they expect law enforcement to be looking for in this type of a case. I think that might help.
Okay, yeah, that would be helpful. And I guess, are
Thank
they
you.
establishing? Oh, am I out of time?
Sorry, you are Mr. Moore. But
Okay. Thank
yeah,
you.
thanks very much. Mr. Kellaway, I have you up next for 5 minutes. Go ahead, sir.
Thank you, Madam Chair, and hello, colleagues, and to the witnesses today. Thank you for this conversation, a very important one on so many different levels. My questions will be directed to Ms. Smiley. The pandemic, Ms. Smiley, has been challenging for Canadians from coast to coast to coast. That would probably be the understatement of the year. Isolation measures such as remote learning and physical distancing and self-isolating and quarantining can put some children at risk of physical, emotional, sexual, domestic abuse, and neglect. So I'm wondering, based on your research and understanding, what can be done to identify and respond more effectively to children who are victims of abuse and neglect in their homes during this pandemic?
Thank you for the question. I don't have these exact statistics in front of me, so we're going to have to follow up with you on this, but they are astounding. The increase in reports of child exploitation during the pandemic. I will follow up on that.
Thank you.
I do know that Public Safety Canada and others in the safety portfolio are working on this issue of child exploitation in terms of making sure that there are services available, making sure that we can leverage technology to recognize victims. Again, I don't have the specifics in what we're doing. I have to get back to the committee on that. But these are some of the things under the federal strategy for gender-based violence that are in place to address child exploitation.
Great. Thank you for that. Thank you for that answer, and we look forward to receiving that information. I'd like to go a little, I guess, deeper in some respects. If there was one area, Ms. Smiley, where you feel this government could further support women, women's shelters, and organizations that support women who are victims of domestic abuse, what would be that area or areas, and why?
So I think what the pandemic has shown us is the critical services and support that community organizations provide to women every day. And so one thing that I would say is making sure that we're providing funding to support the gender-based violence sector is one of the most important things we can do to support survivors, to prevent and end gender-based violence.
And how much time do I have left, Madam
You
Chair?
have 2 minutes left, sir.
2 minutes. I never have 2 minutes left. That's great. I'd like to continue with Ms. Smiley, actually. And I think this was brought up from a previous MP, but I'm wondering if we can go back to it around women's organizations or shelters or both, about what changes they've made to adapt to the pandemic and the pandemic context. And this could be for you or others on this Zoom.
Madam Chair, perhaps I'll start. A perfect example of how some organizations have adapted their services or have leveraged to the best of their ability the pandemic context is the Canadian Women's Foundation hand signal. So women are isolated, not able to access call for supports or to access organizations. And so one thing that the Canadian Women's Foundation did is a campaign to put out a hand signal to increase awareness and to ensure that when people see the hand signal, putting your palm to the camera, putting your thumb and closing your fist, that they know it means on a Zoom call like this that someone is in trouble and needs help. That's one really great example. Another one, our organizations are developing apps. So there's the ARC app, where those who are experiencing gender-based violence can download the app and privately, securely, and safely record the behaviors that they're experiencing. They can upload photos, they can take video, and can provide an evidence base for the abuse that they're experiencing.
And that concludes your time, Mr. Calloway.
Okay,
Apologies for that. Monsieur Fortin, we are going back to you, sir.
Merci, Madame la Présidente.
Well, thank you, Madam Chair. I have a question. I think Ms. Bouchard a little earlier talked about the impacts of the Divorce Act. I understand that controlling and coercive behavior could be a reason for someone to seek a divorce, but are there other behaviors which could get a victim to ask for a divorce, other such behaviors? I think I'm the one who talked about the Divorce Act. Can the witness please hold the mic to her mouth? Thank you. So just to confirm, you would like to know how the Divorce Act plays into the issue of controlling or dominant behavior. Yes. So what I would say to that is that the Divorce Act is not as wide in scope as as family law at the provincial level. So the Divorce Act would only capture certain aspects of divorce. There's divorce itself. There is parental arrangements and alimony or child support. So in C-68, there's a definition of family violence, and this would apply to how separation arrangements are hammered out. So that's already included. I'm sorry, Ms. Farid, we don't have a lot of time. I just want to refocus my question here. I understand that domestic violence is defined in the Divorce Act, but what I'm talking about is coercive and controlling behavior. So what is the connection between controlling behavior and the Divorce Act, apart from saying this could be a reason why someone would want a divorce, but what's the interplay between those two things? Well, that controlling behavior is not necessarily included as a motive for getting a divorce, but it would be included in determining what the best interests of the child are and custody arrangements. For instance, dominant and coercive behavior is included in the definition of domestic violence, which is used to determine the best interests of the child. So a judge might determine that there should be no contact between one of the parents and the child. So this is how controlling behavior or dominant behavior could be applied. Well, I understand there's no definition in the Divorce Act on controlling or coercive behavior. No, there isn't. Coercive and dominant is used in the terminology in the Divorce Act, but it's not defined per se. You're saying those words are included in the definition of domestic violence? Yes, and it's also included in the criteria to determine what the best interests of the child are. Ms. Farid, would you have anything to add with regard to the distinction between controlling behavior, harassment, violence, threats, all these different types of behaviors? No, I'm sorry, I wouldn't have anything to add in terms of those definitions. Do you have any words of caution for us in terms of, a couple having animated argument versus real threats being made, threats of physical violence? My question is, how far can an argument go? How far can it escalate before it falls into the criminal domain? Well, I think it's the nature, or rather one of the aspects of controlling and coercive behavior is the fact that it plays out over time and there's a pattern. And in a family context, it's not just one incident that matters. It's a pattern that plays out over months or years. So that is the main, that's the main factor you have to take into account for this type of behavior. Thank you, Mr. Fortin.
Mr. Garrison, sir, for 5 minutes, go ahead.
Thank you very much, Madam Chair. I want to focus on the link between coercive and controlling behavior and more severe forms of physical violence. Often when we start this discussion, incidents are cited which some people might regard as trivial, but they miss the connection and the pattern of behavior that leads to further violence. The most dramatic information I've seen is a study from Australia which looked at homicides with intimate partner relationships. And in a study of 112 of those homicides, it found that in 111 cases, it involved coercive and controlling behavior. And so in a country like ours, where unfortunately approximately once a week, a woman is murdered by an intimate partner, I think it's very important that we look for tools to intervene earlier. So my question to people on the panel is there a possible role of this kind of criminal offense in intervening and preventing more severe forms of violence?
To whom is that question, Mr. Garrison?
Perhaps Ms. Smiley, but also maybe in terms of the literature that was consulted by Department of Justice.
So perhaps, Madam Chair, I'll begin and then pass it over to my colleagues over at Justice to comment. So as I said, the law is certainly outside of my area of expertise. But what I will say is that the patterns that the member has noted in the research, the fact that violence does tend to escalate, the fact that when one woman is killed every 7 days by a partner, that isn't the first violence that they've experienced.
Perhaps I can take the liberty of adding a few comments to my colleagues. I think your issue relates squarely to the importance of training and risk assessments. And some of that does appear in the literature that the department will share with the committee for your review. But regardless of the offenses that are in place, if law enforcement cannot detect early on risk factors, and as you point out quite rightly, sometimes those risk factors are considered what they call low-level offending. But even though they're low-level and might not even constitute a criminal offense, or even if they do, a less serious one, they may all the same be indicative of very serious offending coming down the line. And that's where training of police officers and risk assessment tools come in. And that issue is highlighted in one of the articles that we intend to share with you.
Thank you very much. I know I'm just about out of time, and so is the committee. I want to return to something that was raised by Madam Finley at the beginning, and that is the impact on children in families where coercive and controlling behavior takes place. And certainly, I'm no expert, but I've begun to learn a lot about this. And I guess the biggest surprise to me was the very direct impacts on children who witness this this form of violence, I guess I will say, in their family relationship. So perhaps again to Ms. Smiley and anyone else in terms of the literature on the impacts on children.
Thank you for the question. The impacts of this type of violence on children, as noted in the literature, is varied. It ranges, for example, from mental health impacts and long-term mental health impacts. Children show symptoms of PTSD, depression, anxiety. Children also show school disengagement and less success in school, difficulty concentrating. And then there also is research that suggests patterns, generational patterns of violence. And so there is research out there that suggests that children who have witnessed violence sometimes do go on and engage in that behavior later in life themselves.
Madam Chair, I know you're signaling we're almost out of time. Let me just thank the witnesses today for getting us off to a good start on our study. And I really appreciate the contribution they've made today. Thank you.
Thank you very much, Mr. Garrison. Now we'll go to Madame Finley for 5 minutes. Go ahead, Madame.
Well, thank you. This is such an important conversation. So I also, again, thank you for your contributions. Ms. Levman wasn't here when I started, but thanks. Good to see you again. I'm just picking up on this again for a moment first. The negative impacts of all this. Although COVID measures have been important and necessary, I'm concerned about these unseen consequences. And when I say unseen, maybe not unseen to those of you who are part of all this for a living, but generally in the public mind, we are hearing as members of parliament a lot of distress and concern about the fallout. And, you know, it's fine for officials to say things like stay home, but home is a safe place for many, but it's not a safe place for the people we're talking about, those who are subject to domestic violence in particular. And addiction and other issues like this are factors. We know in British Columbia, where I'm from, the opiate crisis is very concerning, and deaths are up from that. We hear, at least anecdotally, that suicides are up as well. Pressures and stressors can make these situations even worse, but sometimes they are there just because of how the perpetrator grew up or what they've been subject to in their life. We know that as well. So I'm wondering about, you've talked about a lot of money actually going towards research, data, surveys, analysis, but what about the education of the public in these areas of pointing, you know, is there more, in your opinions, that can be done, or what would you suggest could be done is maybe the better way to phrase that, to make the public more aware that this is something that is identifiable and there are options for actions to get away and to heal? What is being done in the public realm?
Ms. Smiley, go ahead.
Thank you, Madam Chair. So with the research investments that we've made and the national surveys I've spoken of, what we learned is that people often have not intervened when they witness violence because they didn't recognize it as violence. Another reason people noted they didn't intervene is because they didn't think it was serious enough to report. And then the last most frequent answer that we saw in terms of why people didn't report or didn't intervene is because they didn't know how. And so what that tells us is we do need to do more in terms of education. We need to educate people on what gender-based violence, intimate partner violence is, how to recognize it. We need to do more to teach people what resources are out there for help. We need to do more in terms of building people's confidence, self-confidence in intervening safely for everyone. And so what's underway to do that? Under the federal gender-based violence strategy that I talked about, the Public Health Agency of Canada is investing in the prevention of teen dating violence in particular. In our collaboration with provincial territorial governments across the country, we have heard various campaigns that are going on in the context of COVID to educate people on the very things that I've noted. And under the federal gender-based violence strategy, the Department for Women and Gender Equality also has been for awareness and education, which we're currently working on.
Can I just ask you very quickly, are there any specific programs for Indigenous Canadians?
I'm going to have to get back to the committee on that. The short answer is yes, but in terms of specifics, I will need to come back to the committee, perhaps in writing.
Thank you. I appreciate that.
Thank you very much, Madame Finlay. And now, last but definitely not least, we'll go to Mr. Maloney for 5 minutes, being our last questioner for the meeting. Go ahead, sir.
Thank you, Madam Chair. That's with that introduction, I feel a lot of responsibility here. First, let me say thank you to the witnesses, as others have mentioned, for the introduction to this very, very important topic. I used to be involved with the Catholic Children's Aid Society in Toronto, and I've seen some horrific cases which don't need to, shouldn't be repeated. But one of the things I learned a couple of things from that, is that the people involved in the process are heroes, and the system is severely underfunded, which is an issue we can deal with later, I suppose. But a couple of questions on topics that came up earlier. I know there's been discussion about the Divorce Act and the changes that are coming into force on March the 1st with respect to coercive and controlling behavior. I wasn't quite clear on the context of those changes. And some of what Ms. Burridge was saying earlier, the translation went a little bit awry, so I'm not sure if I'm asking you to repeat something which you've already discussed. My understanding of the Divorce Act is that divorce is no fault, so I'm not sure how to contextualize that issue. So if somebody could explain that to me for starters, I'd be grateful.
Okay, so I'm hoping that you can hear me, and I'll speak slowly so that the interpreters. Okay, great, thank you. So I would say that the main way that the issue of coercive and control is being dealt with under the Divorce Act is its inclusion in the definition of family violence. And that definition of family violence is used to determine the child's best interest.
Okay. Right.
And we're using the best interest test in order to determine parenting arrangements. So who has parenting time and decision making with respect to the child.
Okay, that's helpful. I appreciate that. And it's because it's the civil issue. Is the onus different than a criminal context, correct?
It's a civil onus, and the definition of family violence specifically indicates that there does not have to be a criminal offense for the behavior to come within the definition of family violence.
Okay, and this is a brand new provision that's being included in the Divorce Act next month. Okay.
That's right.
All right. Now I'm going to pick up on some questions Mr. Moore had asked about types of behaviors that might lead to be support charges of repeatedly and continuously engaged controlling and coercive conduct. I think he ran out of time when he was asking that question, and I think it might have been Ms. Levman who was about to answer. Is there a list of behaviors somewhere that we can find, and if so, is it part of legislation or a regulation?
Thanks. Yes, I think that your best, one of your best sources in any event is the UK guidance, and on a few pages in, there's a box that highlights or bullets out some of these behaviors, and they range from, isolating a person from friends and family, monitoring their time, etc., all the way to sexual assault, threats, etc., that are criminal offenses, and so that might help you understand what is captured by this proposed new coercive control offense.
Sorry, and that's in the English legislation you're talking about?
It's actually their special prosecutorial guidance. It helps their law enforcement actually implement the new law.
But it's there, not here. Materials. Okay. All right. So there's no there's no similar list of behaviors that's part of this draft legislation anywhere.
Well, you mean private members bill C247?
The private members bill, yeah, sorry.
Yeah, no, but it is, as the sponsor has explained today, based on and heavily informed by the UK's model, which was why I was directing you to United Kingdom resources, which I think might be helpful for you. The United Kingdom is the first country that put into place a coercive control offense, and therefore there's the most literature associated with their offense.
Okay, I'm gonna run out of time here in seconds, so I have one sort of broad question. Could you send us copies of the UK legislation, the Australian legislation, and answer the question in writing, if you don't mind? How do you think this proposed bill could benefit from those two examples, and what are the similarities?
What are the similarities between the different
between the three pieces of legislation, yeah,
that are enacted in the United Kingdom, Scotland, and Ireland?
No, and you mentioned an Australian bill as well. I wouldn't mind knowing having a comparison to that one too.
So that's not law in Australia. It's
a private bill. Members. Okay.
Yeah. So you would like that's four pieces of legislation. Okay.
Right. Thank you.
Thank you very much for that, Mr. Maloney. And I'll take this opportunity now to thank the witnesses for your very compelling and very informative testimony and answering questions today. We greatly appreciate you being here. We look forward to receiving some of the written submissions that we've identified through our members today for some of the questions. And I also want to give a really big thank you to our IT and interpreters for the challenges that they dealt with today, and we still made this meeting work. I really appreciate that, and then to the members also. I'll just quick reminder before I adjourn, the remainder of the witness lists per party are due by the end of the day today, so please make sure that you get them in. Monsieur Fortin, I see your hand raised. Is that a point of order?
Non, Madame la Présidente. D'abord, je comprends que les documents que le témoin...
Madam Chair, I understand that the witnesses will send documents and will have access to them because I'd like to see them myself.
Lorsque vous aurez terminé...
Also, after you thank the witnesses, I would like us to deal with the motion that I raised at the beginning of the meeting.
The documents submitted by witnesses will be available in your digital binder, and so you can access them. Mr. Clerk does make it a point to email everybody also the documents that we receive. So just keep an eye on your email and on your digital binder for the committee. So with that, thank you to the witnesses. Mr. Virani, I see that your hand is raised on the same point.
Yeah, Madam Chair, I've taken off my, 1 second. Sorry, my headset was off. Can you hear me, Madam Chair?
Yeah.
Excellent. I would move that simply, you know, we've had a pretty extensive study this morning and it's gotten off to a very good start. I would move that we adjourn the meeting.
That's again a dilatory motion, Monsieur Fortin.
J'avais demandé, écoutez,
I had proposed that we start off with my motion. I understand that Mr. Virani does not want the committee to study our motion, but we're a committee, we're doing our job. He can vote against it, but I think we'll have to look at it sooner or later.
An update from Mr. Clerk. Mr. Clerk, if you just want to speak to what Monsieur Fortin is suggesting.
Oui, merci, Madame la Présidente.
Thank you, Madam Chair. I believe that what Mr. Fortin wanted to do, and please correct me if I'm wrong, he wanted to suggest that the committee debate the motion he proposed at the beginning of the meeting. And if that's the case, the motion can be considered as a dilatory motion. It can be put to a vote immediately without debate or amendment.
Mr. Clerk, Mr. Fortin's motion is dilatory. It's basically just asking for a debate to resume on his motion.
Yeah, that's correct. So it would need to be voted on prior to Mr. Virani's motion, for instance.
Okay. So we'll call the vote then. The vote, just so members are clear, is to resume the debate on Monsieur Fortin's motion. Go ahead, members, and Mr. Clerk.
Madame Brière?
I'll vote no.
Mr. Cooper?
In support.
Ms. Findlay?
Yes.
Monsieur Fortin?
Oui.
Mr. Garrison?
No.
Mr. Kellaway?
No.
Mr. Lewis?
In support.
Mr. Maloney?
No.
Mr. Moore?
Yes.
Mr. Sarai?
No.
Mr. Virani?
I vote no.
So yeas pour 5-5 et nays contre 6-6.
Thank you very much. So now we're going to move on to the dilatory motion presented by Mr. Virani in which he had moved to adjourn the meeting. So Mr. Clerk, if you can please go ahead and count that vote.
Madame Brière,
Yes, to adjourn, please.
Mr. Cooper,
No.
Ms. Findlay,
No.
Monsieur Fortin,
Non.
Mr. Garrison,
Yes, to adjourn.
Mr. Kellaway,
Yes.
Mr. Lewis,
I vote against.
Mr. Maloney,
Yes.
Mr. Moore,
No.
Mr. Sarai,
Yes, to adjourn.
and Mr. Virani.
I vote yes.
Okay, so yeas pour 6-6 and nays contre 5-5.
Thank you very much, Mr. Clerk. And so the meeting is now adjourned. Thank you, members, and thank you for a wonderful meeting.
Thanks, Madam Chair.